Okay, so finishing up here with the third of the 3 videos on procurement. And what we have remaining are discussion on the remaining 2 processes in procurement, which is conduct procurements and control procurements. And then within there, we'll talk about standard terms and conditions and special provisions. And then also talk about different ways of resolving claims, 3 different methods. It could be mediation, could be arbitration, or it could be litigation. So we'll talk about that. And here's the 3 processes, and the first one we'll talk about in this video is conduct procurements. And what's happening here is by this point you know that there is going to be a contract. You're going to outsource something. So what you're doing is conducting a search to determine who the seller or sellers is going to be. And then this process ends once you've made that determination. And so the main output would be the contract itself, called agreements, and who that seller is or sellers if it's a short list, and as well as a number of other outputs too. Once that is determined, then when you go to monitoring and controlling, you're going to be monitoring and controlling the work of the contractor that has been awarded the contract. So as I mentioned, if this were an RFP where you're going to be creating perhaps a cost reimbursable contract, then you'd be sending out a request for proposal and getting those proposals back from various sellers. You could be a fixed price contract, in which case you'll just be getting bids back and maybe additional information beyond that as well, but not to the customization that you would if it was an RFP. In any case, you will be getting this information back from suppliers and evaluating all of these bids and proposals and then awarding the contract, knowing that you will have to iterate on the terms of the contract most likely, because it's very unlikely that both parties will immediately agree to all terms of the contract right up front. So here's the ITU diagram for conduct procurements. It is an executing process, so it will look a little bit like a control process in the sense that you have a project plan as an input, project documents as an input, and then you have a change request as an output, as well as project plan and document updates too. So that's a common input and output feature of an executing process. In addition to the inputs I just mentioned, you will also have procurement documentation, which, as you recall, part of that it consists of the source selection criteria, which is what you're going to be using to evaluate the proposals. And then the proposals themselves, which come in as input number 4, seller proposals, EIF and OPA. And then for tools and techniques, we have independent estimates, if there are any, expert judgment, advertising as a means of growing your search for additional contractors, bidder conferences, and proposal evaluation, which falls under data analysis, and then of course negotiation, which falls under interpersonal and team skills. So within OPA we have, as I mentioned, qualified sellers list, so those lists that's already been predetermined by your organization as being those that you're able to go after and ask if they would like to submit a bid or a proposal on your contract. So that's if one is available. And then you may also have contract templates to help with writing up that contract, keeping in mind that as the project manager, you're not going to be the one that's going to be writing the contract. It will be whoever is responsible for administering the contract. PMI calls that person a procurement administrator. And then there may also be financial policies on contractor payments. For outputs, then, we have the sellers themselves. We have the contract, which is agreement or agreements, potential for a change request, and then, as we mentioned, project plan and document updates as well. One of the tools and techniques here, then, is a bidders conference. So once you start getting a group of suppliers that are interested in your contract, you might hold a bidders conference where you generally have people on the phone, and you provide information about what the contract is for, more details about the contract, and then allow the sellers to ask questions, and then everybody hears the answers all at the same time, and they're supposedly all on an equal playing field at that point, because you don't have one party that's getting more information on the contract than another party. Be advised that when you do have a bidders conference, even if it's anonymous, that there's always the potential that one or more suppliers could collude offline if they know who the other party is, and then do some type of price fixing. So that is something just simply to be aware of. Then again, as these proposals come in, you will be evaluating them, and you could weight them. There's a variety of different ways that you could use for evaluating them. And if it's a very large project, you might have, in fact, a committee that's going to be responsible for doing the ultimate decision and selection of the contractor. And then you'd be providing a short list for them. And so perhaps it's the committee that's doing the evaluation, or maybe you're involved in that as well. And advertising, as I mentioned, is a way of expanding your list of potential suppliers. A lot of different ways you can advertise. You can advertise online, through the paper, in databases. Government contracts require public advertising, as a matter of fact, and generally what they do is post their contracts that they have open for bid in a database, and then you'd have to go and search the database, but that's technically how they advertise. And as I mentioned, there is a potential for negotiating on the contract. One side or the other is not going to be, completely satisfied with everything on the contract, so you might have to negotiate. Now, PMI's perspective on negotiating is that it should always result in a win-win for both the buyer and the seller. So one party is not taking advantage of the other party, and that you are getting a reasonable price for reasonable work. The other thing that PMI espouses is that you should not, as the project manager, be the lead negotiator in a negotiation process, but that should be the procurement administrator, or perhaps a combination of that person and senior management, but it shouldn't be the project manager. So that may or may not be how it is in your organization, but keep that in mind for the exam, that's what PMI believes. And here are 3 negotiating strategies that you should be aware of. PMI, of course, is not advocating these. They are just strategies to be aware of. They are called out also in the Crosswind book. And the first is the use of competition, where a seller could use someone else or another party, whether that party is a real party or a made-up one, against you just to get you to sign or get the best price or whatever other term they're looking for. You know, you might have come across this if you've ever had to, let's say, buy a car, and the dealer might tell you, you know, we've got 3 other couples that are looking at this same car, so I'd suggest if you want it, you would probably want to buy it today. So that would be competition as a negotiating strategy. Deadline is similar in the sense that now all of a sudden there's an imposed deadline that you're going to have to sign before this deadline, otherwise you'll miss out. And you know, you might hear that by saying, well, all of the terms that I'm giving you right now will no longer apply after today. So if you really want the best price, you're going to have to sign today, because it's all going to be gone tomorrow. And you might be familiar with that one. So that would be the deadline one. And then the boss is missing is where you, as a seller, are using the tactic that you don't have the authority yourself to alter any of the terms of the contract. Only the boss can do that, and the boss is not here. So we can either wait for the boss, and that might be days, or we can just sign right now. And I'm sure you've come across each of these 3 negotiating strategies, so they're just ones to be aware of course. They would not result in a win-win situation. Then you're going to be ultimately awarding a contract as a result of this process. So your output is going to be the selected seller. Although if it's a large group of sellers that you have in mind, you might have just whittled them down to a short list, and then perhaps it's a selection committee that's going to make the final determination of that. So seller or sellers, whichever it is, and then you would draft that contract up with whoever was designated and determined to be the seller for the contract, getting approval from your management and senior management. And then once that approval was obtained, then the procurement administrator and yourself would be able to get the contract signed by the seller. And then you then at that point have an agreement or a procurement contract, which is legally binding. It obligates the seller to provide whatever the product or service was that was stated within the contract in the statement of work. And then it obligates you as the buyer to compensate the seller for any work accomplished. And that's an important point, any work accomplished. You're not necessarily obligated to compensate them for work in the future that hasn't been accomplished yet, but you are for work that has already been accomplished. And if one side or the other doesn't live up to their end of it, it is subject to remedy in court. We talked already about the different components of a contract. Just here's a list of some of the things that you could find in a contract. Okay, so now let's get a little bit into the components of a contract itself. There's terms and conditions, and they are abbreviated as either T&C or TOS, which would stand for Terms of Service, which is what you would call it if it was a website, but T&C a little bit more generic of a term. And terms and conditions are comprised themselves of two parts. Standard, so you've got standard terms and conditions, and that's typically your boilerplate part of the contract, and then also special terms and conditions or provisions, special provisions. And these are custom for a specific contract. So each contract is going to have something unique associated with it, and that's what you would note under special provisions. So the standard terms and conditions will define what the rights and responsibilities are of both parties for the contracted action. So whatever you've decided you're going to be doing in the contract, the standard terms and conditions would define the rights and responsibilities of both parties. You can negotiate these, but if you've got a large company, then it will tend to fall within the company's legal department as far as how far you can negotiate in this case. And the types of things that you'd normally find in standard terms and conditions, your standard boilerplate would be: how are people going to get paid? How are they going to be invoiced? Who owns intellectual property rights? Does the contractor have the ability to subcontract on their own? And if so, does the prime have to vet them in any way? Does the buyer have to vet them in any way? A number of other items as well, which we'll cover in an example in the next slide. So here's an example boilerplate type standard terms and conditions. How often the client will be invoiced, when invoices are due, confidentiality of pay rates, for example, the ability to hire a contractor, and a number of other items can be included here as well under your standard terms and conditions. Special provisions then are going to be added to account for anything that's not involved in part of your boilerplate standard terms and conditions. These generally are negotiated because they're custom for each contract and for each project. And so those are the two main parts, the special provisions and your standard terms and conditions. Okay, so let's talk a little bit about what happens in terms of interpreting a contract and things to look out for when it comes to a contract. That you may know some of these, and this might be also the first time you've heard some of these. It's kind of interesting. So first of all, once a contract is signed, everything that was agreed to prior to that now no longer matters, because the contract is the only thing legally that matters at this point. So if it's not in the contract, then it's not part of the work that's going to be done. So you're only going to be doing what's within the contract itself, or expecting the contractor to be doing what's within the contract itself. Be careful about all of the items that are listed within the contract, especially if you're the seller, because the buyer may be asking for all kinds of things like specific reports, specific inspections, and so on. And if you miss that, then you could be held as not meeting up your part. You could be held as in default of the contract. I was actually involved on a construction project once, and I was brought in because the seller that was doing the construction had not done any of the paperwork required that was spelled out in the contract. They had done all the construction, but they just didn't do the paperwork, and so they were found to be in default. And I was brought in to help them generate project plans and so forth that they needed. They ultimately lost in court, however, so be very careful about everything that's spelled out in a contract. It's also better to, in a contract, to spell out the numbers rather than rely only on numerical characters, and that should be obvious why. And if you are going to modify the contract, that's okay, but it would have to be typed up and attached, made it as an addendum to the contract. Certainly, there's nothing that would count in court as being only verbally agreed to. You would have to type it up and attach it to the contract. If the contract has already been signed, then you cannot mark it up and make changes to it. If it hasn't been signed yet, you can still mark it up and then initial it in the places that you've marked up. But once it's been signed, you can't do that. You'd have to type it up and add it as an addendum to the contract. Be very careful about the statement of work and the scope of work, and that you're very clear as to what you are looking for. Just like we talked about in scope, where we had specific, or actually we had SMART requirements, and that would stand for specific, measurable, achievable, realistic, and time-bounded. Make sure that the requirements within your contract here also fit within the SMART acronym. And then let's talk about a few more interesting areas on the next slide. Jim Loki is an individual that I've done some work with. In fact, he was the one that brought me in for that construction project, because he specializes in helping, especially construction companies, get themselves out of contract jams. And here's some of the things that he teaches actually in some of his classes. And he says that contracts cannot legally have any print that is smaller than a size 8 font. So literally beware of the small print. It wouldn't hold up in court. And that's the printed font, not what it is on the screen. So be very careful if you're a seller as to whether there's any specific terms related to submitting a change request, because if it says you have to have one in within a certain time period, for example, and then you don't get it in, then you end up having to do work for free. A notice to proceed, which you'll find in construction type contracts, doesn't really mean anything. Never proceed, regardless of something in a schedule, without a signed contract. And likewise, never proceed to start work on only a verbal authorization, even if the person that is providing that verbal authorization has the authority. Never do it without a signed contract. We talked about the standard terms and conditions a few minutes ago. The city of Rochester, and this was a few years ago, so I'm not sure what it is now, it might be longer, but a few years ago, the city of Rochester's standard terms and conditions was 250 pages long. That's just the boilerplate, standard terms and conditions. While the U.S. government standard terms and conditions is 1,963 pages. This is another reason why PMI says you should not be, as the project manager, responsible for the contract, because it's literally a full-time job keeping track of over 2,000 pages for a federal government contract and having a very good understanding of the law. or even 250 plus pages for a City of Rochester contract. So really someone with legal experience should be responsible for it. Be careful also about how you are required to communicate within a contract. Again, this would be if you are the seller, but keep in mind these things as well if you're a buyer, so that you're fair with people, and that you may be required to communicate via registered or certified mail, whereas you assumed that email was sufficient, and then you just communicated by email. You could end up being in default if you did not read that carefully. Always think about risk when you are submitting a bid, especially for a fixed price contract. Think about the worst case and then plan your dollars accordingly. I know there's a fine line, because if it's a fixed price contract and there are other people bidding on it, then you have a concern of going too high and not getting the contract. But on the other hand, you also have the problem of not making a profit by bidding too low. Okay, so now we are in control procurements. At this point, the contract is already underway, and your role is to monitor and control the performance of the contractor, just as you would any other part of the project. And it's going to be a control process, so we'll see a lot of similarities with other control processes. So also, you'll be working in conjunction with the procurement administrator. They will need to verify that the terms of the contract are being met. This is also the process where once all the terms have been met, you will do a closeout of the contract. So you'll be monitoring and controlling and then ultimately closing out the contract. So while you are monitoring the contractor's work, other processes are going to be taking place simultaneously as well. Direct and manage project work. Recall that from the integration knowledge area. Control quality. You'll be inspecting the seller's work. You'll be doing a perform integrated change control to make sure that if there's any changes on the contract, that those changes are handled correctly. You'll be monitoring risks to make sure that the risks are being managed correctly, and also monitoring communications among other processes that will be taking place. Remember also that the cost aspect here deals with paying only for completed work. And after you have reviewed the performance, that there might be some corrective action that might need to take place via change requests or preventative actions. And as far as terms here, you might see within the Crosswind book the term contract administrator. PMI now calls it a procurement administrator, but they used to call it a contract administrator, so sometimes you'll see that term, the old term, still in there. And it's very possible on the exam that they would use that legacy term as well. So just make that translation if you see the term contract administrator somewhere. And this is the person that is actually going to be managing the contract, usually with a legal background, and then making any revisions to it as necessary. If you can think of the contract itself as being the law, the procurement administrator would be the enforcer of that contract, or the police. So what's your role as a project manager then? Well, you're going to work with the procurement administrator to make sure that the work results have been done successfully according to the terms of the and conditions of the contract. But you are going to be monitoring the work as well, making sure that everything is progressing and that you're getting the deliverables of the project as were specified. However, if there's any changes required, you cannot change the contract. Only the procurement administrator has the power to change the contract. So with that background, here's the ITU diagram. We have, again, this is a control process, so you should be very familiar by now with the standard inputs, tools and techniques and outputs in your control process, with project plan and documents as being an input, and then work performance data is also an input for the control processes, with work performance information as an output, as well as 4, 5, and 6 there, change requests, project plan updates, as well as project document updates. And then as far as tools and techniques, you see expert judgment, claims administration, we'll talk about that, data analysis, and then the performance reviews is one that you see common for all of the control processes, almost all of the control processes. I'm going to ask you now if you can answer which of the 8 inputs there would be looked at during performance reviews. So during performance reviews, and remember this is a standard tool and technique for control processes, you see this one a lot, which input is used for that tool and technique, or inputs? So you should have thought about number 6 there, work performance data. Those are the actuals. So those are the actual data, actual work result, that raw work that in this case the contractor would have completed. Give you indications of how far along they are, like % complete on an activity, for example, date that they started the activity, whether the activity is completed. And then they could be you will be comparing that against your baselines, which would show up in the project plan, and also against the requirements, which would show up in the project documents, as well as the agreements, which are all in the input there. So you may also have an approved change request coming in, because the contract itself could have resulted in a change request, and now it's been approved and needs to be reviewed. And again, if you look at the tools and techniques now, besides performance reviews, we also have earned value analysis. So if you are doing earned value for the project as a whole, then it's likely that you'll want to do earned value for the contract portion as well. And then based on where you are now, your current results, you can use trend analysis to determine where you'll be performance-wise in the future. Inspection will deal with inspecting the work products of the contractor, whereas audits will deal with inspecting the processes of the contractor. And as far as the outputs go, if you are closing out the contract, then you're going to end up with a closed procurements as an output, or a closed contract. And then also you'll be archiving that contract in OPA. So that's why you've got an OPA update, so that's wherever your files are stored. And any other documentation that you may be updating throughout the course of the contract, as well as at the end, would get updated. And then perhaps plan and document updates that might get updated as a result of perhaps change requests. Some of the documents that you might look at as inputs here would be the assumption log, lessons learned register. You see some of the others, requirements documentation, of course, because you're going to be comparing their work against what the requirement says, the risk register, and the stakeholder register. That's going to be updated, of course, once you've determined who your contractor is going to be, and that could be continuing to be updated as well throughout the project. The EIFs here would include whatever change control system you have in place for the contract. It might be the exact same one that you have for the rest of the project, or it could be a separate one. You also have to make sure you have some type of accounts payable system set up to pay the contractor, and then there may be a code of ethics that's within your organization or maybe even within your industry. As you know, PMI has its own code of ethics, which once you get your PMP, you are also obligated to live up to. Okay, so claims administration is one of the tools and techniques. And what happens if one side believes that the other side is in default of the contract? Then if that's the case, you would submit a claim. And a claim is a contested change where there's not agreement on whether there should be compensation or not generally. If it can't be resolved, it can escalate to a dispute. And an unresolved dispute, in other words, it was resolved but not the way that you wanted it to, can become an appeal. Claims then are documented, tracked, and managed throughout throughout the life cycle of the contract. And if you cannot resolve your claim through negotiating, which is the preferred method by PMI, then the next best method is through some type of alternative dispute resolution, ADR. And that would be stated in advance and written up in the contract. You would have a name of an individual who would be the one responsible for resolving that dispute, and that would be stated within the contract. And so let's talk now about some of these three methods in general for resolving claims. And those are mediation, arbitration, or litigation. So mediation, we'll go through some advantages and disadvantages of each of these three methods. Mediation might be the first method you'd want to try. If you cannot decide amongst yourself how to resolve a dispute or a claim, then you might get a mediator involved. And what a mediator does, they would be named in the contract as the mediator. You would contact them, and the advantage is it would be private. But what a mediator does is they do not make the decision for you. They leave it to you to make the ultimate decision how it's going to be resolved. They are just there to mediate the differences that you have as best that they can. The other advantage is that you can schedule it immediately, as opposed to if you were going to go to court, it would take a long time. And then another advantage is it's not as costly, and you can share the cost of the mediator. So the disadvantage of mediation is that you could walk out and not be satisfied, and or maybe even you are satisfied and then you change your mind, and then because the results are not binding. The best way to approach it would be to agree on how you're going to resolve it, and then write up the agreement as part of the contract so that it is binding, because once it's in the contract, it's binding. the next method that you could be used would be arbitration. And arbitration means that you have to get an arbiter, and that again would be somebody that was spelled out in the contract. And an arbiter would decide how this case would be resolved. And it's an advantage in that it's still private matter amongst the two parties, and also can be scheduled immediately. But now, as far as cost, you need lawyers, so now you've got to pay for the lawyers plus the cost of the arbiter. So it's more expensive than mediation, but still not as expensive as litigation, which we'll cover next. But one of the things about arbitration is that the results are binding. You can't appeal the results of an arbiter. So that could be good news or bad news depending on which way you came out of it. Litigation is the final resort. PMI says last resort. You should only, if all the other ones have failed. It is expensive because you have to pay not only your lawyers, but then you also have to pay court fees. And it takes weeks, maybe even months, to get on the calendar. So that could be an issue, especially if you're the seller that thinks you should be getting paid, and yet you can't get your case heard for 6 months. That means that's at least another 6 months that you're not going to get paid. So that could be a problem. The other thing about litigation is that it's public. Anybody can see the result of the case. And also, it can be appealed, which once again could be bad or good. If you don't like the way the outcome was, you can always appeal it. But that could be a bad thing too, because then you could be tied up in court for a long time. And that's why, in general, litigation is not the best approach. You should try to negotiate your differences without having to resort to litigation. So you'll be doing, as I mentioned, inspections of the work of the contractor as detailed in the contract itself. And this is the work products. So inspections applies to work products that they've created, whatever the deliverables are. And audits would be inspecting the processes that were used to create the work products, and making sure that whatever process they have in place is being executed according to the terms of the contract. And we talked about performance reviews earlier, and this is where, again, you're looking at work performance data, you're looking at other reports that have come in, trying to understand if there's going to be a variance based on the data that you're looking at against any of your baselines, scope, cost, schedule, or whichever other baseline you have. And then reporting out the information to whichever stakeholders are appropriate at that point. So the output then would be those reports, writing up the performance of the seller in a report, sending those out. If there's any documentation on the deliverables that the seller created, you might be sending those out as well, or archiving them somewhere. As we mentioned, it's a control process, so it's always possible to have a change request. The results of the inspections and audits would get sent out as an output, and then invoices from the seller and payment records would also be archived somewhere as well. Now, to close out a contract, you have to provide formal acceptance to the contractor, and you would do this in writing. So the contractor would likely put in writing to you that they have completed the work to the best of their knowledge and ability, met up the terms of the contract. If you agreed with this, you would also put in writing that you've accepted the work of the contract, and so you've given therefore formal acceptance, which means at that point you can close everything out. Now you have to also have met with the procurement administrator by this point, and the procurement administrator would have to also agree that the terms of the contract have been met, and if they believe that that's been the case, then they would put in writing to the seller that they have met the terms of the contract. And then when you close things out, you should be sure that there are no outstanding claims that still need to be decided, that there's no outstanding invoices that need to be paid, there's nothing on the issue list or any change requests that are still open. And so that everything basically has been taken care of. Then you could archive all of that documentation in the contract file, which is going to go out to OPA. Make sure you close out any cost accounts, etc. And if there's any closeout reports that need to be done, those need to be done as well. And what happens in OPA? So, as I mentioned, the contract file itself is going to be archived into the procurement file. You might update the pre-qualified sellers list, perhaps, as a result of this contract. You might have an evaluation of their performance that's been that you'll write up and archive. And then you want to make sure you have the formal acceptance documented and placed in with that contract file. And then if you've done lessons learned, which PMI is really recommending and emphasizing happen, that would be documented as well, along with any particular recommendations. So here's a question for you then. Which resolution method is binding in its decision? You should have said arbitration. The other two can always be appealed, but arbitration is binding. At what point in the procurement process is a make or buy decision made? It should be the plan procurement management process, the first one. At what point in the procurement process is the contract managed? Hopefully you thought of control procurements. The contract hasn't started yet in conduct procurements. That's when you're still searching for a contractor. So these are the topics that we covered. 3 processes, so know what the names of the processes are and what process group they're in. The 5 components of a contract. Think of cold cola. So you've got capacity, you have consideration, you have offer, you have that it's a legal purpose, and you have an agreement. Those are the 5 components. If you're doing a make versus buy decision, then be familiar with how to do a break-even equation for that. Be familiar with the names of the 3 different types of fixed price contracts, as well as the 3 cost reimbursable contracts, and which one benefits buyer versus seller more in terms of risk. Remember the formula for the point of total assumption and the formula for calculating share. Point of total assumption also has an element of share in it. And then the bid documents, those are like the RFP, RFQ, if you recall, RFI. 2 types of statement of work. There's a scope of work, which is design, and then there's a scope of work which is functional. So know the difference between the 2. Different methods for source selection, and this is how you're going to pick a seller. Are you going to use least cost, whoever's got the lowest cost, qualification based, or a combination of qualifications and cost? Or are you going to use sole source, meaning you're only going to look at one seller? Be familiar with the different procurement strategies, which are design build, design bid build, design build operate, design build operate and transfer, and the difference between standard terms and conditions and special provisions, and then the 3 different methods for handling claims, the alternative dispute resolution methods. So arbitration, mediation, and litigation. And that's about it as far as procurement.